Today in this lecture we will discuss the duties and the liabilities of the trustees. This topic mainly deals with the sections of the trust ordinance. When you see these sections 11 to 56 of the trust ordinance generally relate to the duties, specifically sections 11 and 12 that we will see now. And liabilities of the trustees deal with sections 23 to 31, and rights of the trustees deal with sections 32 to 37, and powers of the trustees deals with sections 38 to 47, and the disabilities of the trustees deal with sections 48 to 56. There are certain cases also under English law as well as in Sri Lanka, but mostly this topic, as I told you, depends on these sections of the trust ordinance. First of all, we will see the section 10 of the trust ordinance. Trustee may accept or disclaim the office of the trustee. There is a full choice given to the trustee or the person to accept or disclaim. A trust is accepted by words or acts of the trustee indicating with a reasonable certainty such acceptance. Then section 10.3, a trust is accepted by words or acts of the trustee indicating with a reasonable certainty such acceptance. Then this is a way the trustee may accept the office of the trustee. In an express trust, when you see there, first of all, when they draft a deed of trust, they mention the name of the trustees. But if they don't want to be a trustee there, then they can disclaim there. But in the law of Sri Lanka, the conveyance of land must be constructively accepted by transferee. But this would not amount to the acceptance within the meaning of section 10.3. Because as we have studied, when you create a trust, there may be two documents. One is known as deed of trust. Other one is deed of transfer. Because the property is immovable property or land or something that should be transferred to a trustee. That's a separate transaction should be executed. In addition to that, the first place there must be a deed of trust. Then if a person accepts the deed of transfer, it doesn't mean that he accepted the office of the trustees. But there are cases, in the charitable case we have studied section 107. 107, the de facto trust in relation to the charitable trust. The court has the power, in the absence of any formalities in relation to the creation of trust, the court has the power to declare that there is a trust. In those cases, this is a case given Ranasinghe versus Dharmananda, such a trustee is recognized in the English law, and since trust has been received into our law from English law, it is necessary to use the terminology of that law. If a person by mistake or otherwise assumes the character of the trustee when it really does not belong to him, so he becomes a trustee. by way of actions, he has done something, then he becomes a trustee. Then always we can't expect to do something, to say something, or they must give the acceptance in writing or not. But even by action, it may be he becomes a trustee of the trust. Then in this one, McDonald CJ also held that since the trustee deeds on tort had required title by prescription to the property adjacent to the trust property, he acquired it as a trustee on behalf of the trust. Then if he gets some sort of other rights also, if he gets those rights as a trustee, then it belongs to the trust. Then we will see the section 11. This is one of the important sections we must study very carefully. Trustee is bound to fulfill the purpose of the trust and to obey the directions of the author of the trust given at the time of its creation, except as modified by the consent of all beneficiaries being competent to contract. Now the basic idea here, trustee is bound to fulfill the purpose of the trust. Then when we execute a deed of trust, we must specifically say what is the purpose or what is the objects of this trust. Then always trustee is bound to fulfill or bound to achieve the objects of the trust. In addition to that, obey the directions of the author of the trust, whatever given at the time of creation of trust. The directions in the sense, author of the trust, at the time of execution of the deed, he can give something in writing, or sometimes it may be in, he can speak some words, even that may be a directions, what you should do, what you can do. Sometimes maybe in relation to the performance of duties, sometimes it may be performance of the powers, whatever it is. Obey the directions. But even the directions are there, but certain cases the directions can be modified by the consent of all the beneficiaries being competent to contract, because first of all the beneficiaries must be a persons who are competent to contract. That we have seen in the first place, who is competent to contract. Then in here also, if they are competent to contract, then all unanimously decide that we will modify this one. And second thing is subsection 2, where the beneficiary is incompetent to contract, his consent may, for the purpose of this section, be given by court. Then if the beneficiary is under age of 18, then the court has the power to give the consent on behalf of these minors. When you see this section very carefully, then we can see this one. First of all, we will see duty to obey the directions of the author of the trust. Nothing in this section shall be deemed to require a trustee to obey any directions which are impracticable or illegal or injurious to the beneficiary. Then we have said that in terms of section, in accordance with the section, trustee must give effect to the directions of the author of the trust. But even though, if the directions are impracticable or illegal or injurious to the beneficiary, then there is no such obligation of the trustee to obey such directions. The guiding principles for trustee is to obey the directions of the settlor. And that's clear always. The general principle or guiding principle for the trustee is to obey the directions of the settlor. For example, if you take an example here, when an author of the trust has directed calling in of all the monies and investing the same in purchase of real estate, the trustee must comply with the direction. And in the case of breach of such direction, he has to make good the loss if there be any, as a result of such breach or default of such direction. Now the direction given here in the example that we have seen, the direction given to call in all the money and purchase a real estate. Then the trustee is an obligation or comply with such direction and do it. But if he fails to do those things, then there's a breach of trust or breach of directions. Breach of directions, and then it may lead to the breach of trust. The first place, it is a breach of directions. Then he has to make good the loss, if any be any, if there be anything, as a result of such breach or default of such direction. Further, we can see where the trustee has been directed to sell the property within a prescribed time, he shall be liable if he fails to sell within the prescribed time. In the event of that property being afterwards lost by destruction, then he is liable. The clear idea here, now here the trustee is directed to sell the property within a prescribed time, within a specified time. Say, suppose within 6 months time you must sell the property and distribute the proceeds to the beneficiary. But then you have to do it as much as possible within 6 months time. Otherwise you are liable to the loss of property or whatever afterwards. Then within the 6 time you have to do it. If you can't do that, if anything happened to the property, then the trustee is liable. It is important to note that the explanation to section 11. Now we will move to other slide here that talk about the explanation. When you read this explanation, unless contrary intention expressed, unless a contrary intention be expressed, the purpose of a trust for the payment of debts shall be deemed to be A, to pay only the debts of author of the trust existing or recoverable at the date of instrument of trust. Then the trust, actually here the purpose, the creation of trust, the actual object of the trust is to pay the debts. That's all. Then what we should do is we must pay the debts of the author of the trust on the date on which the trust deed executed. When such instrument is a will, then at the date, actually we must see the date of death, because last will in the sense, last will comes into effect on the date of death of such person who has executed. Then finally, in the case of debts not bearing the interest, to make such payment without interest. Now there are simple explanation given. The purpose of the trust to settle all the debts of the author of the trust. He has a property. He has given the property also. Then what we should do is, that is the direction. You must settle all the debts. Then what we should do first place, the debts. Then we have to calculate the debts. Then that should be, we must see the date on which the instrument of trust executed. Then first of all we must notify the date, and we must calculate on that date how much of debts to be recovered. Then if it is a last will, then the date of death of such person. Then if the debt, say suppose we must pay the interest, then we must pay interest. If there is silent or if there is no interest to pay, then we should not pay interest. If you pay the interest as a trustee, trustee pays the debts together with the interest. In such case, he is liable for the interest, because interest is not required to pay, but in terms of the deed of trust. But if he pays, then he is liable to such amount. It is important to note that the explanation to section 11 is subject to the terms of the deed of trust. Now this is an explanation given, but always we can't rely on this one, because this is just an explanation. But then what is the idea here? Always you must see the deed of trust. Always it is subject to, sometimes you may pay with the interest, sometimes trustee is required to pay the debts plus interest, sometimes trustee is required to pay only the debts, not the interest. When the deed of trust does not make any provision for the payment of interest on debts, no such payment can be made by trustee. If he makes payment beyond those specified in the deed of trust, he would amount to the breach of trust on the part of the trustee. Suppose the deed of trust requires the trustee to pay the debts without interest, but he paid with the interest. In that case, there's a breach of trust. Then it would amount to the breach of trust on the part of trustee. Then we will see here duty of the trustees to distribute the trust property. When a trustee declines to carry out the directions of the trust, then the court will direct him to implement the same. Because the directions given by author of the trust, because always we have seen, we must see the intention of the author of the trust to identify the purpose. Even we have seen that we must identify the intention of the author of the trust, whether to create the trust actually. Then we have seen when we study this express trust, we have seen intention of the author of the trust. That should be clear. Then here, if the trustee declines to carry out the directions of the trust in the sense, it may be in the deed of trust, or sometime at the time of execution of deed, the author of the trust would have given some idea or given some guideline how it should be dealt with. Then in that case, if the trustee declines to carry out the direction, then the court will direct him to implement the same. In terms of rules of the English law, the trustee will be justified in ignoring such directions in the trust where they happen to be illegal or manifestly injurious to the trust. Then when you see the duty of the trustees to distribute the property, The trustees are under an obligation to distribute trust property only to the beneficiaries who are entitled to it. Now the trustees are under an obligation to distribute the trust property only to the beneficiaries who are entitled to it. But there are some more beneficiaries who are not entitled to it. Then the trustee would be held liable if the distribution of the property gone to the wrong person, because that's limited to only to the person entitled. Then if the trustee pay outside that, then he is liable. That's why here we say that the trustee would be liable if the distribute the property. If they distribute the property to the wrong person, even if they did so on the legal advice or wrong construction of deed of trust, they are liable. Sometimes the trustee would have got some legal advice. Sometimes he interpreted the deed of trust and come to the wrong construction. In that case, there is no excuse at all. He would be held liable to the payment. But they will not be liable if they have accounted to an apparent beneficiary on the face of the instruments of trust. The trustee have an undoubted right to ask any person who claims to be a beneficiary to prove his title. First of all, if the trustee wants to clear whether he is a beneficiary or not, first of all, he has the right to ask any person who claims to be a beneficiary to prove his title. And in the case of doubt, they may seek directions from the court. Where the trustee have discretion in the exercise of their powers, they must exercise their powers bona fide. Then we have seen that always we must comply, the trustee must comply with the directions. He should not go out of the direction. But if the directions is something illegal or manifestly injurious to the trust or beneficiary, then he can, the trustee may deviate from such directions. Now, when you talk about deviation from directions, when you see this section 11, in the view of section 11 of the trust ordinance, if a trustee deviates from the trust, he may be held liable for the breach of trust. Then the deviation is not permissible, but we will see, however, sometimes, such deviation may be necessitated by statute. For example, when a trust property is compulsorily acquired by the state under Land Acquisition Act, this is because there was no legal bar for the state to acquire any portion of the trust property. Whatever it is under Land Acquisition Act, if the government or state decided to acquire the land, they can acquire. The government on behalf of the state, the government or government's divisional secretary or somebody can acquire this land. Then there is no bar whether it is in the trust or whatever it is, the government or state has the power to acquire such land in terms of Land Acquisition Act. When there is such an acquisition of the trust property, deviation from the directions of the trust is inevitable. Then you have to deviate, the trustee should deviate from the directions given by author of the trust. But in that case, the trustee is not liable. Further, it will be open to the court to sanction a deviation if it is beneficial for the trust. Sometime at the time of creation of trust, that may be all right, but after some time, after 5 years or 2 years or after some time later, it may be a issue. There may be a difficulty. There are some difficulties. Then what we should do is we must ask the court. That's why it will be open to the court to sanction a deviation if it is beneficial to the or for the trust. But court would not ordinarily permit a trustee to deviate from the directions of the author of the trust. Then in principle, trustee should not deviate. Even court will not allow to deviate. But there are some special circumstances. There are some special situations in which even the court can grant permission to deviate if it is beneficial to the trust. If a situation arises which was unforeseen by author of the trust and the trustees are not able to take the consent of the beneficiary, then the court may take administrative jurisdiction by sanctioning the acts of trustees. Now we have seen in principle all the time trustee must comply with the directions. But there are some cases, statutory requirement, as we have seen in the law. Land Acquisition Act require the government or state acquire certain land. It includes the trust property. Then in that case, it is possible to deviate. That's why then in that case, the deviation from the directions of the trust is inevitable. Can't do anything. But there are cases, there are circumstances where if it is good for the beneficiary, it is good for the trust, it is good for the beneficiaries, then the court may grant sanction. And also we have seen there are some unforeseen circumstances, unforeseen by the author of the trust. Now it should be done, then the court may interfere and take administrative jurisdiction by sanctioning the acts of the trustees. And we will see the modifications. Now, deed of trust is there and the directions are issued by author of the trust. Now we want to modify that. And can we do it? And the section, when you see the section 11 of the trust ordinance provides that the directions of the author of the trust given at a time of its creation may be modified by the consent of all beneficiaries being competent to contract. Therefore, if the beneficiaries for the time being competent to contract can collectively modify, they can do it. They can collectively modify the directions of the author of the trust and distribute the trust property among themselves as they think fit. This act is valid. Modification is acceptable to certain extent. I don't say that always beneficiaries get together and change all the things. That cannot be done. There are limitations, but still modification is acceptable. When the estate is directed to be sold and the proceeds to be divided among several persons, it is open to the beneficiaries collectively agree to take the land as such without being sold, and trust may be put to the end. It does not mean that Section 11 of the Trust Ordinance empowers the beneficiaries in unison to modify the duties of the trustee to fulfill the purpose of the trust. Then that's a very important point here. It does not mean that Section 11 of the Trust Ordinance empowers the beneficiaries in unison to modify the duties of the trustee to fulfill the purpose of the trust, even to deviate from or disobey the directions of the author. The directions contained in the trust deed are immutable. You can't change it. Now we will see the section, we will move to the next slide here. Then the section 12. Now what is section 12? The trustee is bound. Trustee is bound to acquaint himself as soon as possible with the nature and circumstances of the trust property, to obtain, where necessary, a transfer of the property to himself, subject to the provisions of instruments of trust, to get in trust money invested on insufficient or hazardous security. And this is something very strong section, provides some sort of obligation to the trustee. When you see this section 12 of the Trust Ordinance enumerates some of the vital duties of a person who accepts the offer of the post of trustees. He is bound to execute the trust with fidelity and reasonable diligence. Fidelity and reasonable diligence. Then he is bound to execute the trust with the fidelity and reasonable diligence. In order to do so, he has the first and foremost duty to perform, which is enumerated in section 12 of the Trust Ordinance, such as a trustee must acquaint himself with the nature and circumstances of the trust property. He must obtain, where necessary, a transfer of the property to himself. Subject to the provisions of instruments of trust, he must get trust money invested in sufficient and non-hazardous security. The first duty a trustee has is to acquaint himself with the nature and circumstances of the trust property. He is under legal duty to inquire as to what property form part of the trust property before taking possession of the same. In the first of all, there is a legal duty to inquire as to what property form the trust property. He must also look into the trust instrument to make himself conversant with the terms of the trust deed, ascertain the encumbrance, and acquaint himself of all other matters affecting the trust. Then he must look into the instrument of trust, deed of trust, to make himself conversant. to make himself conversant with the terms of the deed and ascertain any. Sometimes there may be encumbrances, then you must see that also, encumbrances, and acquaint himself with all the matters affecting the trust. It is not open to a trustee to adopt a policy of extreme inactivity because he is to hold office without remuneration. As we have seen, the trustees are not entitled to the remuneration. Remuneration may be given or may not be given. That's not the issue here. The trustee is bound to find out if the property is subject to a charge or assignment. If it is so, subject, and in ignorance of such charge or assignment, he makes payment, he would be personally liable to assign your encumbrances. Then if there is assignment or charge, then first of all you must pay and discharge those things. So where the trustee, for a married woman, having received notice of a charge executed by her and had made payment to her, he was held personally liable even though the charge was disputed by her. He would be personally liable if he makes a false representation to an assignee. In fact, the moment the court declares such right of the charge holder, the trustee becomes a trustee for him also. If a share or in a trust fund in its distribution has been previously assigned, trustee cannot claim any right to delivery of the assignment and other document of title before the payment of share to the assignee. As we have seen here, trustee is bound to ascertain as to whether there is any encumbrances on the trust property or whether the beneficiary has created any encumbrances over his interest. So, where the trustee paid the beneficiary without taking note of encumbrances made by beneficiary over his interest, and of which trustee could have been aware if he really made proper inquiry and examination of the trust property, trustee was held liable to make good the loss occasioned by the payment by the trustee to the beneficiary. Then if there is an encumbrance, then first of all the trustee must sort it out and pay such money or whatever and settle first, and thereafter only. If he ignore those things and do something, then again the trustee becomes another trustee to that person also, the assigner or the charge holder. A trustee is not an insurer of the estate which has been undertaken to administer as trustee. His conduct has to be judged with reference to the facts and circumstances which are actually known to him or which he ought to have been known at the time when he takes action with reference to the trust estate. One of the duties trustee, after he acquaint himself of the trust property, is to obtain, where necessary, a transfer of the property to him. While pressing for such transfer, he shall not be swayed by the feeling of relative or friends, or be determined by the consideration of delicacy. If the transfer is not completed within the reasonable time amicably, he should not hesitate to bring appropriate legal proceeding for such purpose. Now the action, if there is a issue, then he must take action against the person. To get the land, get the title of the land to the trustee. It is clear that when he cannot take possession of the trust property without instituting a legal action, he cannot stop on making demand from the person in whose possession the trust property is, but has to start recovery proceedings against such person. Then there is a mandatory obligation to the trustee to get the trust property. First of all, he must ask the person to convey the property to his name. If he fails, without waiting for a long time, without any unreasonable delay, he must file an action in the court of law. The trustees are allowed some amount of discretion as to within which period he is to realize or reduce the trust property or money in his possession. Where the trustee, in his discretion, to have allowed certain time to lie over the investment on foreign bonds, and as a result of which the securities has subsequently been deteriorated in value, he was exonerated from the loss caused to the trust, as it was found to be an honest error of judgment. Because all the time, trustee can't be liable to each and everything. There may be an honest error of judgment. In those cases, he should be exonerated. Even in the case of secured assets, the trustee is under a duty to call in the money where there is a depreciation of the security. When the investment of the trust fund is in the partnership firm and there is such change in the constitution of partnership firm as it would involve the risk of continuing such investment in said partnership, it is a duty of the trustee to call in such money from the partnership firm. When the investment of the trust fund is in shares of the company, and the shares have altered in value, it is a duty of the trustee to convert the same with the money within the reasonable speed, so that it does not become unauthorized investment. When the assets of the trust are invested on mortgages, then if the trustee is satisfied about soundness of the security, the trustee need not call in such investment unless it is necessary for the proper course of administration of the trust estate. The question would be otherwise. Where there is a risk to the continuance of the investment in security having depreciated in value, in such case, the trustee has the duty to call in the amount. However, the duty can be administered by the trustee even if by the term of the instrument, a change of investment is to be made with the consent of tenant for life, and latter does not consent. The first of all, there are conditions. But there is a risk. But when you transfer or to change the investment, the trustee must get the consent of the tenant or the beneficiary. In those cases, trustee has no time to do it. Our trustee couldn't do that. In that case, this is because trustee has duly protect. Why he has done like that? This is because trustee has the duty to protect assets of the trust from being deteriorated in value. When we see this one, duty to get in trust money invested in sufficient or non-hazardous security. Non-hazardous security. A trustee has special duty in respect of investments on personal security. He should not allow assets to remain personal securities. This is because the debtor's position may change from day to day. This duty extends even with regard to the investment on personal securities by testator who created the trust by last will. Therefore, if the executor or the trustee allows the assets to continue on personal security and they are ultimately lost or recovered partially, the executor or trustee, as the case may be, will be personally liable for the loss to the estate. However, trustee would be exonerated from the liability if he could show that if necessary steps were taken even promptly, they could not have been recovered. Even if I take, the trustee might say or may say, but even if I have taken or if I do whatever it is, this cannot be done. Something like that. Because anyway, it must go wrong. That's why here we say that trustee would be exonerated from the liability if he could show that if necessary steps were taken, even promptly, they could not have been recovered. That cannot be recovered even if I have taken actions. Then it is made clear that if the trustee has done all he could obtain payment, but his efforts have not proved successfully, he is undoubtedly exonerated. But if he has taken no steps whatsoever to obtain the payment, but it appeared that even if he took prompt step, he would have been unsuccessful, or there is a reasonable ground for believing that they would have been ineffectual, then the trustee is exonerated from all these liabilities. Then we will go to section 13. The next slide we will see. What is section 13? A trustee is bound to maintain and defend all the suits and take all such other steps as regard being had to nature and amount or value of the property may be reasonably requisite for the preservation of the trust property and assertion or protection of title thereto. When you see this section, it's another important duty of the trustee is to take all necessary steps for the preservation of trust property, subject to any special provisions in the instruments of trust. It is the duty of any trustee to do all acts which are reasonable and proper for preserving and protecting the trust property. Then it is a general duty, it is a duty of the trustee to do all acts which are reasonable and proper to preserving and protecting the trust property. For such purpose, Section 13 makes it incumbent for a trustee, subject to the provisions of instruments of trust, to institute and defend legal proceedings and take all steps as may be necessary and reasonably for the preservation and protection of title of the property. When the trust property has been improperly alienated by his previous person, then it is a duty of new trustee to recover the same. And you see the protection of title of the trust property. It is a duty of the trustee to see if anything remains to be done to perfect the title to the trust property which has the duty to duly carry out. Yes, protection of title of the trust property. It is a duty of the trustee to see if anything remains to be done to perfect the title of the trust property. The illustration, I don't put it here, you can see the trust order. Illustration to this section 13, indicates one such measure. If the title of the property is imperfect due to the non-registration, it shall be the duty of the trustee to complete such registration of trust property. In its duty for preserving and protecting trust property, the trustee is bound to exercise good faith and care and prudence as an ordinary man would exercise in respect of his own property, and to preserve and protect the same for the benefit of beneficiary or substitute trust. The duty of care extends to the ordinary duty of trustees. The trustee is not bound to exercise a right of preemption in respect of property adjoining the trust estate. Now we will see the section 14. The trustee must not for himself or another set up or aid any title to the trust property adverse to the interest of the beneficiary. Now section 14 forbids a trustee not to set up or aid title adverse to the trust property. Second thing is not to set up or aid a third party's title against the trust. This is because the position of the trustee being fiduciary, it is not open to him to set up any title adverse to the beneficiary. The rule that a trustee cannot be permitted to invoke the formal title in him as against the cestui quo trust is well settled rule of equity. The principle underlining the provisions of this section is that a trustee who has accepted the office of the trustee must assume the validity of the trust and the title of the beneficiary of the property, trust property. Under the provisions of this section, a trustee is not permitted to invoke formal title in himself in respect of the trust property adversely against the interest of beneficiary, nor should be act in a manner inconsistent with his duty as trustee, nor does he takes a benefit a breach of trust. If a person knows that a certain piece of land has been transferred to him as a trustee, he cannot be allowed to allege that an absolute beneficial title to it, regardless of the trust. That if the property is transferred to the trustee, then he should not accept it. He must object and he must take action to prevent those type of situations, those type of title. It is held that what is the case in three, it must be appeal cases. In Bray versus Ford, it was held that trustee shall always avoid a situation when there is a conflict between his own interest and his duty as trustee. When there is a conflict between his own interest and his duty as a trustee. Moreover, a trustee cannot undertake a duty or act in a manner which would be inconsistent with the duty as trustee. He is also prohibited from purchasing a trust property that we have seen earlier also. However fair such a deal may be. However fair, trustee should not purchase the property. Similarly, a trustee cannot retain any benefit for himself in respect of any dealing or transaction relating to trust property. It is well settled that trustee, being a fiduciary position, should not make any profit out of his position. If the instrument of the trust provides for any remuneration to be given to the trustee, he can be permitted to accept such remuneration, not anything else. That's why we have seen generally trustee is not entitled for remuneration. It doesn't mean that the remuneration should not be paid to the trustee. If it is paid, he should not expect anything more than that. That's why here, if the instrument provides for if the instrument of trust provides for the remuneration to be given to the trustee, he can be permitted to accept such remuneration, not anything else. It is also made clear that he cannot use trust fund for his own business. And if he does, the profit which derives by using the trust fund will go to the benefit of the beneficiaries. However, it incurs loss, then he is to make good the loss himself from his own fund, out of his pocket. The trustee is forbidden to take a commission from the person with whom the trust fund is invested, even when the trustee acts in his personal capacity as broker. Now suppose the trustee is the broker. He has done something for the benefit of investment or whatever for the benefit of beneficiary. Generally the commission may be given, but he should not accept the commission, because in addition to the broker, now he acts as a trustee. Then therefore he can't get any commission from such arrangement. A trustee is bound not to connive with fraudulently and knowingly facilitate any act or conduct of the third party which would amount to the breach of trust or result in loss or risk of trust property. Now what we are seeing is the trustee cannot set up third party's title against the trust. Trustee should not, the first place we have seen, you see, trustee should not get any own interest. He should not get anything for his benefit that we have seen. And also we have seen trustee cannot set up adverse title. Now we will see trustee cannot set up third party's title against the trust. The trustee is duly bound not to connive with or fraudulently or knowingly facilitate any act or conduct of third party which amount to the breach of trust or result in loss or risk of trust property. He shall not set up or aid an adverse title or claim of another person against the sesquique trust, even if he bona fide believes that third party has the right in the trust property. He cannot. Even he bona fide believes that the third party has a right in the trust property, he cannot, after accepting a trust, decline to perform the trust. It may be there, he must perform the duties of the trust and also or treat the same to be a part of the trust property. After accepting the office of the trustees, when it is public trust, that's charitable trust, and the beneficiaries have the right of worship and manage its affairs, the trustee cannot deny that it is a trust, or that trust was not created for public purpose of religious or charitable institution. But now it is a public trust, then he should allow to others for the worship or whatever. If a trustee takes such adverse attitude, he is liable to be removed from the office. Now we have seen up to now this very clear idea. We have seen certain liabilities and rights of the trustees. We will see the balance later. Thank you very much.